the city's agent to transform the city's own property, which had become an eyesore, into a resource for public use. The plaintiff did so pursuant to a completely transparent process, working as the city's designated agent. Doing so in accordance with terms specified by the city involved a team of professionals, architects, surveyors, draftsmen, engineers, lawyers, all engaged by the plaintiff at considerable expense for the purpose of transforming this property in accordance with the city's wishes. Then at the last minute, the city changed its mind and withheld the very cooperation that was necessary for its agent to fully perform the parties' agreement. What part of this story, we ask this court, implies the rule of contract zoning? And we submit that the court's answer to that question, which is the basis upon which the trial court dismissed this case, is that no part of this story implies contract zoning. Everybody agrees that the seminal case is Hartnett, and we ask, that's the Supreme Court's decision, we ask that the court begin its analysis there. In that case, the Supreme Court invalidated an ordinance passed by the city of Coral Gables because it was the subject of certain collateral side agreements in which the city exacted from a landowner concessions, not only relating to its property, but also the obligation to provide police protection in the vicinity of a planned development. These were quid pro quos, and the Supreme Court in its decision emphasized that fact by identifying those 6 collateral side conditions with a series of italicized ifs. And what the court held is that a municipality cannot do that. The court described those series of ifs as improper conditions, not only because they involved concessions from the landowner, but because they took place outside the public's view, and that is something that a municipality can't do. The reason for that is that, as the Supreme Court indicated, openness is required when it comes to land use regulation, because the public, and in that case the interveners, or the plaintiffs rather, were adjacent landowners, because they have the right to know.
It's not just openness, it's also the ability through the democratic process for the citizens to weigh in. If it goes in front of a zoning commission, goes in front of a city commission,
Correct.
People can testify, they can lobby in the public sphere. If it's a contract between one party and the city, it could be done in plain view, but nobody else has standing to be able to effectuate the change that may be favorable or unfavorable to neighbors or other citizens of the municipality. So why isn't this like what the 5th DCA said in Morgram, which is this is a cautionary tale for dealing with cities and governments?
Well, we know what the 5th DCA said, that it's basically announced as a rule of developers beware when you deal with government. And that makes sense in the context of what happened there. And it's important to remember that a private party came to the government, and I don't want to use the word bribe, but that's essentially, I think, what the Supreme Court is speaking to in Hartnett. A private party came to the county, Orange County, and said, we're going to give you a 50-acre park if you give us favorable concessions with regard to our own land. That's what the Supreme Court is speaking to in Hartnett, and that's what they're talking about when they use the expression bargaining away of the police power. That simply didn't happen here. The owner of the property in this case, all the way up until the end, and in fact it never happened because all the transactions were not consummated because the zoning was necessary, all the way up until the end, this city started the ball rolling by asking private citizens to come and help it dispose of its own property in a way that would allow for public use. It specified the terms and conditions, and I think it's important for the court to recognize this is a very important fact. The sine qua non of this deal is that a school ceases to be a school. It was zoned for use as a school, and the contemplated use by the city in its own request for proposal necessarily required that this property cease to be a school. One of the things, it's perhaps an irony, but it shouldn't be lost on the court. One of the things about the parties' agreements in this case is that they actually prohibited the developer, that would be my client, from using this property in the future as a school, right up there with an adult entertainment center and a dry cleaner and some other prohibited uses. In other words, they prohibited the plaintiff from using the property in accordance with the existing zoning requirements. That is really exactly what happened in the Palazzo case. And I know that the city has pointed out, and it's true, that the decision doesn't speak directly to the issue about whether or not contract zoning was involved. But it's very clear from the decision that in that case, there were concessions that were expected and anticipated from the city with regard to development that it wanted, and those were essentially later promises, commitments that were reneged on.
But the ultimate disposition of this case came about because there was a vote by the city council.
Right.
Your client's request for this change was defeated by a 1-4 vote. Is it your client's position that the city council was obligated to pass it?
No, absolutely not, and that's what the separate process is for. And we lost there, and I don't think that the defendant seriously argues that that bound the trial court. They're sort of back and forth on that. But we don't anywhere contend. There's no request for specific performance. And as in any other case in where the claims are promissory estoppel or breach of contract, the party seeking money damages is not seeking for specific performance of those obligations. As with respect, because this is not a case of contract zoning, as would be true in any other civil action where money damages are sought, they had a right to do what they did. They just have to pay for it, because this case is not a case of contract zoning. And I would urge the court to consider in particular some of its prior authorities, because I would suggest to the court that Griffey in particular and the city of Melbourne in particular, that those cases read Hartnett exactly the way that we do, that what a city or a municipality can't do is exact concessions in consideration for a zoning change from an existing landowner. The city of Melbourne case it's an older case, and it's from a time apparently when Melbourne was part of the 4th DCA, but it's still good law. There was, as there was in this case, a public purpose initiated by the city that was to build public housing or low-income housing within.
So is your client's position, let's say hypothetically this was not because the city went out one day and said we want to rezone the old Boynton High School, right, and have it changed to some use and revitalize downtown Boynton Beach. It was just like any other plot of land, not necessarily owned by the city. A developer comes in and hires lawyers and architects and contractors and spends tens of thousands, if not hundreds of thousands, millions of dollars, goes before a city. They think they've got all their ducks lined up in a row, and the staff's on their side and is recommending it to the city council, but the city council, for whatever reason, because that's just what city councils sometimes do, they say no. Why should your client, because this was somehow city initiated as opposed to developer initiated, have any greater remedy than would the developer who ostensibly followed all the rules, but just simply was told no?
I think the difference is it's not merely the initiation, but it's whose interests are being vindicated. In this case, Your Honor basically described Morgan, the facts of Morgan, where the developer comes. The developer is relying upon assurances that they're going to get a zoning change. The developer tries to sweeten the pot by giving something that that Hartnett actually forbids, an inducement to the municipality, and the municipality makes the contemplated or promises to make the contemplated zoning change. This is a different situation because this was all for a public purpose that was initiated by the same agency of government that is later claiming that it was acting without its own authority when it did the very thing that it did pursuant to a request for proposal. It's not merely that the city was initiating the process, it's the fact that the city hired someone to do the work at the city's request for a public purpose. That's a very different circumstance, and I'm urging the court to consider if the rule of contract zoning is to be applied, then it should be applied in those circumstances where the purpose of the rule is present and needs to be vindicated. That just simply isn't the case here because everything was transparent, and this court has in fact drawn that same distinction in its other authorities. But in the City of Melbourne case, what the court said was that when this was for this public purpose, that the cooperation agreement between the involved parties, which required, there's no other way to read the agreement, the city says so, but there's no other way to read the agreement, and I see that I'm running out of my allotted time, there's no other way to read the agreement, but that the city had to provide the zoning change that was indicated. It could do so according to this court because it was a lawful change for a lawful purpose. And I know I ran over a little bit, but I would like to have a little bit left.
We'll be happy to give you an extra minute or two on the back end.
Thank you, Your Honor.
Thank you.
Good morning, Your Honor. George Roberts on behalf of the City of Boynton Beach. Just a couple of comments on what Mr. Sales has said. Attached to the complaint, to every complaint, are two documents. In the Fourth Amendment complaint, there were three documents attached. One is a agreement to deed. The part of the agreement, there's a developer's agreement, and then there's also agreement to deed the property to it. This is the entire deal, and both of these agreements require that the city and must approve a comprehensive plan amendment, a site plan approval, and a zoning change. And it says it must approve it as a part of this deal, and when they did not approve it, the deal's off. And that's exactly what happened, and they're contending that somehow that did not restrict the city. And as Judge Levine pointed out, that's exactly what it did. It restricted the city because these agreements said, you can hold your hearings all you want, but when it comes down to it, you must approve it.
The irony, as Mr. Sales is pointing out, is that according to the city knowingly entered into a contract which the city now argues was illegal from the outset.
Well, and that's exactly what happened in Hartnett, and exactly what happened in Chung. It's exactly what happened in all the other cases that we cited. There was a contract that they knowingly entered into.
Doesn't the concept of fair dealing have some place in this analysis?
Well, that's not been raised below, and it was not raised in a complaint, and so it's not been addressed in the briefs. So certainly that's a feature of some of the other cases that have been cited.
Well, Palazzo references the fair dealing, but doesn't the fair dealing, I think that when they mentioned Palazzo was talking about the zoning process, which I assume is more of a, to make sure that there's transparency in the process, whereas contract zoning talks about things that where the citizenry are not necessarily akin to it, where in the zoning process they are a part of the
Sure.
process. So is that a way to sort of distinguish Palazzo from?
Well, certainly. If you read Palazzo, it has a long litany, I think, of multi-years of transactions between the city and they sued the city officials because of their intentional interference with their contractual relationships. There's much greater history that deals with it. And obviously, from reading Palazzo, we don't know exactly what the complaint said and what all the allegations were, other than it was a lengthy process. And I think, to your point, that the fair dealing really goes to that rather than contract zoning, because Palazzo doesn't even talk about contract zoning. It doesn't even state it in there. It says there might be, and also in Palazzo, it was the first motion to dismiss that was granted with prejudice. And so this court simply, one of the holdings, the holding of Palazzo really is that the lower court held that cert was the only remedy. And this court said, no, it isn't. There might be other remedies that you could bring. And other cases have recognized when there's an early dismissal that there might be other opportunities to bring other claims. This is the Third Amendment complaint. This is the fourth try. Nothing ever changed. No other allegations were made in this case. Another thing is that in his brief and also in oral argument, Mr. Sales says, oh, we're just an agent of the city. Read the contract that is attached to the complaint. Section 1413 clearly states that they are not an agent of the city. This is not an agency contract, and if they were an agent, they could sue as an agent-principal relationship. But that's not it. You read the contract, what does it say in bold letters? Developer and city. They are nothing more, as you pointed out, Judge Gerber, a developer who simply said, responded to a request. The city has this property, this 28,000 square foot building built in 1927, has been a school for 50 years, but it's been used for various different things. They want to renovate the downtown area, much as the community redevelopment associations do. So they want to do it. They want it developed in a certain fashion, and so these people submit proposals. I will develop in this certain fashion. You look at the attachments. They stand. It's going to cost $7 million to develop. In the attachments there, they're going to make $3 million off of it. The city is not paying them to do that. The city entered an agreement and said, we'll do this, you do that, whatever. and different conditions and stipulations that were a part of these agreements. That is the essence of contract zoning.
What about the alternative count for promissory estoppel? I understand the way that the developer pled the promissory estoppel was that the alleged promise was to approve the zoning change.
Right.
And I understand that it was a third amendment complaint, so they had 4 chances to state a cause of action, and it's possible that the court may have thought it's futile to amend one more time, but couldn't it have been amended to say the promise was not necessarily to approve the zoning change? The promise was that the contract that we're entering into is valid. We're relying on you, the city, as the experts on municipal law, to enter into a contract that you know to be valid, and you promised us it would be valid, and it's not valid, and we relied on that to our detriment. Why isn't that a cause of action which could be stated?
Well, number one, because it was never argued in all of the briefs. Number two, the contract, if you read the contract, says is that if there are any reliance, it's only upon a city manager, not the city commission. And whatever the city manager knows, there's a specific provision that addresses that. And obviously, Morgran speaks very clearly to that issue. You should know, you as the person enter into that they don't have the ability. That's been cited in Morgran, that's been cited in Chung, that's been cited in Hartnett, that you deal with your peril as a city because of this, because if you attempt in your agreement to restrict them to do and contract away their police power, then at your peril that might happen, because that's an illegal contract, it's void. And that's exactly what happened in this case, is that this is a contract which restricts their ability to hold the hearings and do whatever. The other cases they cite don't address that issue. They talk about Broward County versus Griffey. That particular case, Judge Reddick's found something essentially out of the air that this was illegal contract zoning. And the court says, no, it isn't. What happened, this court said, in reversing it, this is not contract zoning. This is just a condition of approval of development. You want to go forward with approval of development, you have to contract this land. And when your development fails, you can't come back and say, oh, I want the land back. That's all it was. It was nothing about contract zoning. Griffin doesn't even say that this is somehow an exception to contract zoning.
So hypothetically, if the city had approved this zoning change, and the developer comes in and actually starts doing their work on the project, and some citizen shows up one day and files a petition to set the agreement aside, and say, this was contract zoning, I protest what my city has done. Under your theory, that could have happened too, and the city's defense to that lawsuit would be, well, hold us harmless because you can't we have immunity on these type of situations. You can only go after the developer. They're out even more out of pocket.
Well, essentially that sort of argument was addressed at the Housing Authority versus Melbourne, because it was an interveners next door that wanted to say that this was contract zoning, and neither the city nor the developer brought that up. And this court found that they didn't have standing to do that. So that was the holding of that case. Also, I think the same issue was addressed in Molina, because there again, in Molina, the issue of contract zoning was brought up by interveners, neighbors or whatever, citizens, and essentially the court, it wasn't brought up by the city, it wasn't brought up by the developer in that case, in the settlement thing. And this court said, essentially, it's irrelevant that you want to bring that up. It has to be something between the parties in this case. I think that in order for these cases that they cite, and they haven't really addressed it, is that, if you want to say that this is not contract zoning, you have to rely on cases which essentially talk about the subject to be established precedent. And neither of these cases really talk about the subject. It's not, the only issue that comes up is Chung, where it says, if it's the implication of Molina, and they use the term implication because there's no discussion of it. If the implication is because it's a settlement, it's enforcement of a settlement agreement, then Chung says that still is contract zoning, whereas this court's essentially saying, well, we didn't find there to be a restriction on the ability of the parties to go forward looking at the agreement. We don't know what the agreement says, it's not a part of the decision, but essentially it says, listen, this is a settlement agreement, that has been approved by the court. And that seems to be the point that makes the difference there, is that this is approval of a settlement by the court, and therefore you're directed to comply with it. And essentially, in the Molina case, the court said, we don't find anything in that order or the stipulation that restricts their ability to follow lawful zoning. And in fact, in the housing authority, the same thing. It was just a cooperation, and it didn't say that you were restricted in doing it, because they just would cooperate in doing any zoning change that they lawfully could do. So the question here is that, he says from the outset, is this contract zoning? Two judges below, and we submit that it in fact is. And that's exactly what it is, and under Hartnett, the case should be dismissed, and we ask the court to affirm it. Thank you.
Thank you, Mr. Reynolds. Or Mr. Roberts, I should say.
Very quickly, we did not abandon our estoppel claim. I urge the court to look at pages 8, 16 to 18, and then our prayer for relief. With respect to the issue about reliance upon the representations and the issue of agency, at page 550 of the record, the first paragraph of the development agreement says that the developer was designated by the city. That's part of the basis for our claim that we were agents. But more importantly, the same paragraph referred to by my friend at page 561 of the record says that we're not joint venturers, as opposed to any specific agency relationship described in this development agreement, recognizing that the relationship between the parties is one of agency.
What about Judge Gerber's point, though, that the promise that's pled in the promissory estoppel account might be the wrong promise? Any argument with regard to that?
Again, I would respond the way I responded previously. We can't make them approve the deal that they asked us to bring to them. We can't make them do that. But if they don't do it, if it's not contract zoning, they have to pay. And what they have to pay is for a later day, but they have to pay. If I may, the cooperation with respect to reliance upon representations, the cooperation that's required is described at page 553 of the record in a paragraph.
Can I just ask you a question? 'Cause I'm sorry.
That's all right.
A seminal question, it seems to me, to your argument. If it's contract zoning, X. If it's not contract zoning, Y. How do you define contract zoning?
I would define it, if I may, Your Honor, the same way that it's defined in Hartnett and in Chung, which is one of the cases upon which they rely, and I'll paraphrase now, but that is an agreement between an owner of property for concessions in land use regulation in exchange for consideration supplied by the owner of the property. That just didn't happen here. If I may very briefly, the cooperation is described in Article 3 of the development agreement at page 554 of the record. And then, importantly, in response directly to your question, Judge Gerber, this agreement is approved and signed, I don't remember his name at the time, by the city attorney at 562 of the record. And where is it in what we do in life that we shouldn't be able to rely on that type of representation? And then finally, if it would make for, the rule of Morgan makes some sense. If you come to the developer and essentially, euphemistically, I would say, try to bribe an agency of government with a consideration for a favorable zoning change, there's some sense and logic to a rule that says that, but it would make for incredibly bad policy. And we understand it's the rule, developer beware, but it would make incredibly bad policy for this court to reason not only that government can't be trusted when it comes to zoning matters, but the government can't be trusted when it hires somebody to develop its own property. And that's really what's behind all of this. But most importantly, because contract zoning does not apply, the trial court relied on decisions which did not bind the trial court and not the decisions of this court, and we ask your honors to reverse. Thank you.
Thank you, Mr. Sales. Thank you both. Thank you. Have a good day.